This court remains in session. You may be seated.
Go to the third case on the docket, almost after the discussion. That clock, I just realized that clock's off by now. Otherwise, we're zipping through these. So the next case on the docket, Security Vet versus Town of Reddington Beach.
Good morning, today, please the court, final seal, Jenny Marie, on behalf of the appellants and property owners. If I may, I would like to reserve comments for both. The order on appeal granted the town's motion for judgment on pleadings, and in doing so dismissed and denied the owner's claim for injunctive relief, which is count 3 of our first amendment complaint. The concern is a pure legal question of statutory interpretation. The appropriate standard of review is de novo. The owner's claim for injunctive relief alleged the town violated Florida's customary use statute, which is section 163.035. The trial court clearly recognized the nature of the claim at the start of this order on page 5 of the record. The court's denial of the claim for injunctive relief hinged on its erroneous interpretation of the customary use statute. The order should therefore be reversed and remanded with instructions to properly interpret that statute because the court misinterpreted it as it relates to the town's ordinances in the following ways. First, the trial court failed to acknowledge that the statute expressly applied retroactively to local governments in which to quote keep in effect customary use ordinances that are enacted after January 1st, 2016 and before July 2018. The town's ordinance was enacted in June 2018. The retroactive application of the statute is also constitutionally permissible, as the town had no vested rights adversely affected.
We talked about this gap period because that's kind of really important. You know, we know basically that this ordinance was enacted before the effective date of the statute, but it was enacted in the gap period. So, the statute itself doesn't make it clear to me that because it was in the gap period that the ordinance would be effective. Walk me through that. Help me understand that.
Yes, Your Honor. So that is why the keep in effect language in subsection 2 of the statute is so important. If the actual ordinance is already in place, meaning that it was passed and enacted after January 1st, 2016, then that 18-month period of time in the gap that you're on reference. In order to keep it in effect, a local government would have to go through very stringent requirements laid out in the statute. Among them, actual notice to the impacted owners, having a municipal hearing where there's notice of evidence that's demonstrated as
We understand what the statute requires, but to go back to Judge Morris's question, is your position that the town, when this statute became effective, had to engage in another process whereby they first rescind or vacate the earlier ordinance, or do they simply not take any action to enforce it? That's the first part of my question.
So what the town needed to do was exactly what the county did. And at that point, the county had passed its ordinance in March of 2017, in that same 2-year period of time. It looked at this statute, interpreted it the right way, and said, okay, if we want to keep in effect our customary use ordinance, we have to go through the process that's laid out, which they did.
So now in this situation, the town did not do that. And if the town like this one does not do that, there's a cause of action for the affected homeowners, correct?
That is correct.
And then there's another part of the statute, which you are well familiar with, and I think we all are, which says basically that the section does not apply to a governmental entity with an ordinance that was in effect on or before 2016, January 1, 2016. So no dispute about that. Does not deprive a governmental entity from the customary use of the defense in any preceding ordinance adopted before July 1, 2018. So that section seems to be a carve out of the keep in effect language. I don't disagree with you. The first part says, if you're gonna keep it in effect, you need the judicial determination. But then, if you keep it in effect and you don't do anything, somebody can sue you, and you can still have to prove that this falls within the customary use language. Why is that not a reasonable interpretation?
I understand that. So I'll go back to one. There is a perfect example,
What they did,
right?
I'm not certain they were required to do what they did if the trial court and the 11th Circuit's interpretation of the statute is correct. They did it, but they may not have had to. They might have had pressure from homeowners, and they decided, you know what, let's do it. We'll do it over. What the heck? Town of Reddington, I don't know if they had that pressure or they didn't, but they elected to do nothing but wait.
Your Honor, so the 11th Circuit Court of Appeals interpretation of this statute rendered the first section of subsection 4 meaningless. It would replace that date of January 1st, 2016 with the date of July 2018. You can't.
Your interpretation vitiates subsection 4, which says a party can sue and you, town, can raise as an affirmative defense, and in fact, it's the necessary requirement, and then you get your judicial determination.
But the affirmative defense that's being carved out here is not one of exemption or being grandfathered. Excuse me, they're laid out in statute. That's how the affirmative defense.
But it's just in the nature of a town. I'm gonna use some terms that I don't want anybody to read too much into it, but a town that chooses to ignore the new statute, they still can protect what they view as the beachfront access if somebody chooses to sue them. Because the homeowners might have chosen not to sue them. So be it. Then everybody lives with it as is. Or could that be a reasonable interpretation, or at least one that the legislature left open?
No, Your Honor, because if that were what was intended by this, then it would the effective date, there would be no express retroactive application. The date of January 1st, 2016, which is the July 2018. But there's a distinction. If you pass or enact your ordinance between those 18 months, and you can still preserve your affirmative defense of customary use. And it's by no
So
means.
how did you ever raise the customary defense of affirmative use? Or the affirmative defense of customary use? I said that.
In just to clarify, you mean the context and how that.
In the context of that subsection,
Right.
you just said, okay, there's this affirmative defense. Under what circumstance would the city raise it?
When it was sued for a takings claim.
But that's not, as the 11th Circuit pointed out, that's not what the language of the statute says. The language of the statute says that you can raise the affirmative defense in any proceeding challenging an ordinance or rule adopted, and this is to be critical, before July 1, 2018. So there is some tension between the two sections of the statute, but this seems to be pretty specific. If you adopted something before 2018 and you get challenged on it, you can raise the affirmative defense.
The legislature intended that compliance with statutes means local government waits to that point in assert customary use. It would.
I'm not sure I understood what you said.
So the practical effect of that interpretation, that any local government that passed an ordinance within that time period could comply with the statute by merely waiting to get sued and asserting that defense.
That seems to be what section 4 permits, because it does specify if you enacted it before July 1, 2018, here's what you can do. You can sit back. I mean, that's why I said, don't read too much into my question. I'm trying to understand it. But it seems to say, you sit back and do nothing. You're not supposed to keep it in effect, but if somebody challenges it because you left it in effect, you can still raise this as an affirmative defense. So the court can now determine whether or not the customary use aspect is valid.
In that case, would not have used the words keep in effect.
But they also wouldn't have used affirmative defense for any ordinance that's adopted before July 1, 2018.
So going back to Walden County, in that case, the owner did sue after the March 2017 ordinance was enacted. But the county didn't realize it needs to go through the process of doing the notice, having the public hearing at the governmental level, and then taking that to the Supreme Court and seeking a declaration before it even enacts the ordinance. So it went through those steps. It was also getting sued by owners. The owners, it was their prerogative to be the plaintiffs. But it doesn't mean because we insert an affirmative defense that owners are deprived, impact owners are deprived of all the due process that's being provided by way of the statute. Very stringent notice requirements. Everything that's supposed to happen below didn't happen in this case. There's no deprivation that's expressed in the plain language of the second half.
And you do recognize though that the court didn't say, the appellate court did not say that the town had to use that process. It just observed that they did. It was not, there's no holding that, of course, this is a requirement. That's what you have to do. They just said, okay, this is what the town did. Now we get to rule on the merits of what they ruled on.
Understood, Your Honor. I think that the intent here is to put bluntly the question to the judiciary, and the retroactive application goes back to January 1st, 2016. That's what's in the plain language. So read into the statute, subsection 4, that what that date really should be is July 2018, because you're carved out or expressly provided the opportunity to present affirmative defense of customary use. And the second half of the subsection is in conflict. That's not what how the section reads. So such a revision would be impermissible, as this court ruled Rivercrest case from 2020. So the court's in the trial court's interpretation exempted the town from having to comply with their terms of the statute, and excused the town from providing the actual notice and the other requirements that we went over. The rewrite of the language of subsection 4 gives local governments that enacted customary use ordinances within that 18-month period the opportunity to raise that form of affirmative defense, not being grandfathered, not being exempted from the requirements of the statute, but of customary use. It could be in the form, and Your Honor pointed out, any proceedings. It could be in the form of counterclaim, responding to the declaration that's required to be filed by the statute. In no way does that language obligate the need to comply with the rest of the statute. So this appeal was brought in accordance with Rule 9.130A3B. The trial court's order dismissed our claim for injunctive relief, despite the other having sufficiently alleged clear legal rights to avoid enforcement of the town's valid ordinance because it violates the state statute.
But that's one other question that ties into the injunctive relief question. If we were to affirm the trial court's decision and the case goes to trial on the affirmative defense, for the taking, that can count that's still out there, and the town loses, what happens then? Do you then, if they continue to encourage people to use the beach, would you then have the cause of action for an injunction?
Your Honor, yes, Your Honor. Well, in that case, I think the trespassing laws and our statutes can protect. But what would happen is that
the reason I asked that is there wasn't much of an argument that the trial court erred in dismissing the injunction count, because if you ultimately prevail, you would be entitled to enjoin the town from doing anything to interfere with the right of use. But as I thought about that, it seemed like that's a future perspective farm that could be addressed.
yes, Your Honor, there were trials to go through on the issue of question of customary use based on a improper or invalid statute that was passed in violation of Florida law. That would be, we'd be having a trial that's precipitated by a constitutional statute. And every day that the statute is enforced is a constitutional violation. And it's
You're saying you refer to the statute, you mean the ordinance?
yes, Your Honor, I apologize. Town's ordinance. So where the language of a statute contains an express command that the statute is retroactive, there's no need to resort to the mechanics of statutory construction. And for that proposition, we rely on Metro-Dade County versus Chase Federal Housing Board. In that case, held that whenever, quote, any doubt exists as to the extent of the power intended to be exercised, which may affect the operation of the state statute, the doubt to be resolved against the ordinance in favor of the statute. As for adequate remedy and irreparable harm, the town argues that the owners have a remedy in law because of count 5. He has a flag taken, and that count remains pending. But basically, we're seeking monetary compensation out of that count. If we succeed, we would be successful in having a full compensation fund being paid. So what we law exists perhaps as to that count, not to count 3, where we are seeking the town from enforcing its unconstitutional ordinance that was passed in violation of state law. The policy email that we referenced in the first amendment complaint also supports the other's position. The time the town's council sent that email, there was a court order that it deemed the ordinance invalid and unenforceable.
Council, let me just let you know you're right about 5 minutes. If you want to wrap up on that.
Thank you, John. I'll go ahead and just state that, yeah, the town's directed to the sheriff's deputies was that they do not enforce the trespassing laws. This further bolsters our position that the injunction is necessary.
Thank you.
Reminds me of please support Ryan Beschenfather, and I represent the town of Rowan Beach. I would start by pointing out that in this case, it's a bit of a difficult position that the town is in terms of responding to the owner's argument, because the owner on the one hand says, the way we read the statute, you should have, when July 1, 2018 came, you should have excised the ordinance that you do lawfully pass, and you should follow the process to sue each of my clients, his clients, and do it the way the legislature now has set up, so that we can be in court under that procedural scheme to have the very same trial that the town is desperately trying to have with all of the 80-some witnesses I have, people who have lived in the town who are going to come and testify about customary use with them. And so at the end of the day, we're going to have the same owners and the same witnesses for the town, and we're going to have the same Florida judiciary decide whether the town carries its burden. It's our burden, of course, in front of the defense to establish whether customary use, as the Florida Supreme Court's Monron decision described it, has been proven. And very same.
That may be a practical impact, but I'm not sure how that helps us interpret this statute, unless you say that is consistent with the affirmative defense language in section 4.
Thank you. Just one moment. I'm getting to the point that I'm making. On the other hand, the plaintiffs also say that this is unconstitutional. So if you think through what they're saying, because we want you to take up more judicial resources and more town resources and go back and restart from this other process to drive to a finding of customary use, only for us to make the argument that that's great. Congratulations. The jury said you proved customary use. It's still unconstitutional. So it really, from that perspective, makes no sense. But turning to the interpretation of the statute that got adopted, the town was well aware, and I serve not just as counsel in this litigation, but I am the town attorney for Reading Beach. And our firm, which represents local governments, we monitor what the legislature is doing every year. We understood that this bill was coming through the legislature, and the folks at the League of Cities said it's going to pass. And so we advised our clients who were interested in this, mostly the beach clients, that okay, if you all need to do something on the books, you got to put something on the book before July 1, 2018 comes to pass, because under this new statute, you'll have to go through these additional procedural loops and become much more expensive. And so Reading Beach, one of our clients, chose to adopt the ordinance, recognizing and protecting customary use. And so and in so doing, and when we advise our clients, we read the statute, and we certainly read each, in fact, we certainly read that. But we also read subsection 4, which is a lot longer, and which clearly, at least to my viewpoint, as I've expressed it in my brief, sets up 3 categories. It's the pre-16 category, and those people that's on the bus, you just get to have it, which raises an interesting question, because if customary use truly is unconstitutional, why would it not be before 2016? But that's for some other case to litigate. But then it sets up the 2 categories that now the category that we fall into, which is the 2016 to June 30th of 2018, which gives the Department of Defense, and July 1, 2018 moving forward. The only way a local government can establish customary use is through the statutory process that became effective on July 1 of 2018. And so since my client's ordinance was adopted in June of 2018 under the statute, it gets to continue to be on the books, and if challenged, as it is in this case, and has been in the 2 federal cases that have been consolidated and are waiting for the outcome of this appeal, it can use customary use as an affirmative defense. And so I understand that what their argument is. I understand keeping effect says keeping effect, but I believe I've given you the Florida judiciary's case law on statutory construction and statutory interpretation, and how you judges are supposed to try to figure out what statute says, and we kind of give the effective meaning to all the words the legislature used. Their rule of last stated policy in sub 4 as to how they wrap up the legislature. And so a good faith legal argument can be made by the owners and their very capable counsel. The better argument, one does not require the more mental genetics and resort to legislative history and what the legislature's actual mean and intent, is the town's interpretation that there are 3 categories. We fall into the 2016-2018 category. We adopted an ordinance in that, and as the legislature said, if the ordinance is adopted in that period and you are sued, you get to raise this as an affirmative defense. Their interpretation makes the ordinance go away on 2018. You never have a lawsuit that lets us raise as an affirmative defense, because it wouldn't be in effect as of July 2018. So it clearly reads that part of sub 4 out of the statute. There's no way you can say it doesn't. And so because of that, the town does believe that its position is the right one. I also want to point out, as the sort of look at this, how count 3 is drafted. It first says count 3 injunction, and then it puts the statutory citation 163.035. But then if you actually read count 3, it doesn't really talk about the statute. It talks about this is an action or to keep the trespassers off of our property, and for an injunction, it says temporary, preliminary is the right phrase, and permanent injunction to get rid of the trespassers. And one of the things that Judge Van Berger below pointed out is under the statute, I can't give that kind of relief in this setting, because you're essentially asking me to order people who are allegedly trespassing, who aren't parties to this case, stop trespassing. But that is subsumed in the ultimate question of whether customary use is going to be proved. Because as your honors know from reading the case law, the Florida appellate courts have already ruled that if customary use be proved, Tonerama says it's not a trespass and it's not a taking. And the fifth district here says if you prove customary use, ipso facto, it's not a taking. And so I understand that there's a broad, larger argument in the Florida judiciary. It's probably going to be resolved with the first district litigation that's going on. That's probably going to be the first Florida appeals court to get to the ultimate question. And even then, since the Florida Supreme Court adopted Tonerama, the Florida Supreme Court's going to have to decide the issue of is the customary use doctrine when applied a taking. All my client is saying is we've got Tonerama. It incorporates customary use into Florida law. We believe believe, because we commissioners who have, many of us lived here for 20, 30 years, and who hear from our residents who have lived here a long time and know what the uses of the future are. We want to protect that customary use. That's a right, by the way, that the town didn't create. The test ordinance, if you look at it, the read ordinance process, it says, we believe that this right is existing. We're trying to create a balance between the owner who clearly did buy their property. The town has never said that he owns complete title and fee to the property, with the rights of the residents to go out and do what they've been doing for decades, which is setting up their umbrellas and so forth. And so that really is what this ordinance is all about.
But let me go back to the statute on one point that really hasn't been argued today. And that's subsection 3 and how that interacts with 2 and 4, because subsection 2 says the governmental entity may not keep in effect an ordinance along these lines unless there is a judicial declaration, which, if you read that by itself, suggests that once the statute is passed, ordinance is in effect and invalid. Subsection 3 says, but you can affirm, you don't have to pass a new ordinance, but you can affirm it by giving notice of intent, and then you follow the procedure for notice of intent. And then, of course, paragraph 4 sets up the procedure for the defenses. So how do we square the language of keep in effect or may not keep in effect with, well, it's not void because you can't affirm it. So it's not void based on the passing of the statute. How do we interpret those two?
Subsection 3, I believe, uses the phrase seeks to affirm. And that is in the English language, prospective, an action perspective, that we are going to seek to do a thing. Since the statute did not come into light until July 1, 2018, all the legislature is speaking to there is local governments who, on or after July 1, 2018, seek to affirm. This is the process that you will use.
The point that I think I'm driving at is if you can affirm an ordinance that was passed in the gap period of 2016 to 2018, then it isn't void as of the passage of the statute, despite the keep in effect language. Because if it was void, then you wouldn't need to affirm it. To me, you would need to pass a new ordinance. I'm not sure if that makes sense. Nobody's really arguing that, but I'm trying to make sense of these 3 different subsections and figure out how that middle, how subsection 3 ties in, and what does that suggest about subsection 2 and subsection 4.
And clearly, I wish that I had happened to get to the word process on this statute, because it's not as well organized. And
But nobody seems to admit that it's ambiguous in any way.
well, I think what the case law teaches us is that if plain English words are used, you follow all the plain English words. And so the town's position is subsection 4 is clearly not ambiguous. It's just not. It says, it recognizes that there are ordinances or rules that can be adopted between January 1, 2016 and June 30th, 2018. It clearly says that, and it clearly says that if those are challenged, then with the government being challenged is to assert customary use of affirmative defense. There's simply no way you can give those words and at the same time agree with the owner's position that on July 1, 2018, all such ordinances have to go away. There's just no way that you could do that. Sub 3, I read sub 3 as saying, if you haven't done any of this yet, but you're a beach community or even not a beach community,
You want to be proactive, you can do it.
if you want to be proactive, do it this way. And sub 2 simply says, you can't on or after July 1, 2018, adopt an ordinance unless you've done it according to sub 3. But, and they probably should use the word keep in effect, because it then creates this tension with.
Well, of course they did, and that's there's some plain meaning to that as well.
I understand the sticky wicket that.
And factually, there's no dispute. Town has kept it in effect and has now been challenged. And so your position is one way or the other, customer use is going to have to be determined.
That's correct. From the town's position, and we were almost set to go to trial in front of Judge Covington in federal court, but then this appeal got filed and Judge Covington waiting for the outcome of this. But the town's position, so that you understand, is that our shot is going to be at trial. And we're going to have all our witnesses come in and they're going to offer what they're going to offer, and the court's going to decide. And so if the court decides you didn't carry your burden, then it's done. That's the last hope the town has for its people to try to preserve their customary use. And so the ordinance will go away. I mean, I'm not going to advise them trying to keep the ordinance on the book when the court has ruled that we couldn't improve customary use. But it's the town's right to do, we believe, under the statute, under subsection 4, to get to that spot. And so that's.
So this just came to me in terms of the procedural aspect of the case. If we rule in your client's favor, this case goes back to the trial court, the federal case goes forward as well. Are there potentially two avenues and two possibilities to get a ruling on the historic use?
So it's virtually certain that Judge Covington over in federal court will be the first trial. If you affirm the opinion below, because she was teed up and we were all teed up and ready to go. That Mr. Teal's firm does not represent the federal plaintiffs. In that case, it's a different law firm, but yeah, so we would go to trial there and we would get a finding from that trial, and then eventually Judge Ramsberger could have his trial if he does it. I would not argue that the federal outcome isn't in any way preclusive, because it's a state law question. Property rights are a state law issue, and so the federal courts can decide what the federal courts can decide. Interestingly, what may be in your head is, okay, so if the federal plaintiffs, which are different from this plaintiff group, they end up losing and this plaintiff group wins, or vice versa, if we have some homes where customary use applies and some homes where it doesn't apply. Yes, we could, but guess what? Under the statute, so could you as well, because you have to sue each individual property owner all along the way, and who knows what that jury is going to decide. That's technical process. So, unless there are any other questions, I'm going to back the rest of the.
Very good, thank you very much.
To clarify the way the statute works, my understanding is that the circuit court action seeking declaration to be affirmed would be an action that require necessitate the government to send actual notice yet again to all owners. Those owners would then have the opportunity to intervene in that action, but it wouldn't be that has to sue each and every person. And to your point, Silverman, regarding subsection 3, subsection 2 case may not adopt that. Subsection 3 says cease to affirm. And I think that if the legislature meant to say that there's any sort of exemption, they would have used the same language above.
But reading those two together, it does suggest to me that the keep in effect language is not to be interpreted as the ordinance is immediately void. The reason is, you affirm a void ordinance, you would pass a new ordinance. So, it seems to me subsection 3 may work in favor of the appellee's argument more on your side. But I want to give you a chance to tell me why I'd be wrong with that.
Well, I think that if it were that way, you have to read adopt in order to adopt.
But how would you keep in effect a void ordinance? If it is void under subsection 2, you don't keep in effect by giving notice and following procedure. It seems to me the legislature has created yet another option, which is, okay, we're saying if you want to, it's not going, you can't keep it in effect, but you can affirm it, so it's not really void, but you affirm it. And then in subsection 3, but if you don't do either of these things and a homeowner sues you, you can raise the affirmative defense, all of which takes us to the same place, which is a court in one of these three scenarios is going to determine customer use.
And I want to address that because I understand the town's position that we're gonna right back where we are, except we're not, because it's not under technicality. We've been deprived of a record below, we've been deprived of the process, we've been deprived of the actual notice from after countless municipal hearings that note. Mr. Ettinger has meaningful things can happen when impacted owners and residents are involved in the process.
The
Perhaps,
new ordinance might not get passed.
exactly right, Your Honor, and we don't know that because it didn't happen. It involved the statute. If we had to sit at the table, perhaps it would have gone differently. Perhaps all of this would have been avoided. I think that's exactly what the legislature intended to do when it passed this statute. But as the relief that we're requesting, we're not seeking an injunction against everybody in the world who might conceivably walk into the private beach area. The practical effect of an injunction would declare that the town is wrong. They passed their ordinance in violation of the state statute. And therefore, there is no valid enforceable customary use ordinance that's currently on the books. Unless there's any further questions, the owner respectfully requests a ruling that properly interprets the state's customary use statute such that it applies retroactively. The ordinance is enacted after January 1st, 2016, and for the court to reverse the trial court's order to ban instructions consistent with its rulings.
Very well. Thank you both. Well briefed and well argued. I think we understand the issue.
Thank you.
Thank you.